Hey all, here is a replay version of the most recent live stream Q&A on all things Social Security that occurs every Wednesday at 1 p.m. Eastern Standard Time. So this is with all the little silences carved out of it. So I hope it's an easier listen for those who are doing the replay versus being there live. And we'd love to see you live. So feel free to pop in. Bye-bye now. Natasha's in the house. Hi, Natasha Johnson. Nice to see you. If you are only applying for SSDI, why do they submit for both? They don't. I'll tell you in a minute. If you already know that you don't qualify for SSI, what happens when they process your application? They don't automatically make an SSDI application and SSI application. You either had to say you wanted it or you clicked the wrong button when you did your online thing that says, yes, I want to apply for that. That said, the opposite is not true. If you apply for SSI, they are obligated to see if you are eligible for SSDI on the date you allege you became disabled. And that is because SSI is welfare, and they need to know if you have other sources of income that should be applied for to prevent you from having to take from that SSI trough, if you will, what we were just talking about before, because you have other wherewithal. So if you have SSDI, should you be getting SSI off your neighbor, basically? So whereas SSDI is something you earned, you worked for, it's insurance you bought and you're insured for because you chose to do that. Well, you chose to work. Otherwise, the taxation for the insurance is compulsory. We've talked about that too. I think Jen, me, and I touched on that last week. So yeah, you might have that backwards or someone clicked the wrong button. It could be if you did it online, on the phone, which I never recommend. If you cannot do that, I wouldn't. And they automatically clicked it. They could have just accidentally done it, the intaker, But otherwise, if you file for just SSDI, there is going to be no SSI filed for, unless you proactively do it. And you have to wet sign the documentation and or attest by phone that you did so. That's how they help prevent fraud. Okay, so I hope that clears that up. What were we talking about, LaRocha? What would be an upgrade for the lower to middle class folks? What, LaRocha? You talking about the PCW's proposed SSI restoration? No, it won't. That would cause you more taxes to pay for it. I don't know where you're getting that from. No, you're totally mistaken. Lower to middle class folks don't have SSI. You see, the zero, the very low income can have a little bit. Remember, income counts against SSI. So once you get over a certain bare minimum of income, dollar for dollar, it's, $1 for every two if it's earned, dollar for dollar if it's not earned, like it's gifted. So I don't know if you guys are actually thinking about it fully the right way. LaRocha, it will increase taxes for the lower and middle class. PCW, I do agree with you on the numbers, should be raised. So I do support that. Not sure about the in-kind thing. We've already affected the in-kind thing greatly when what do I want to say? I almost want to say equalized. If you are paying the one third of the federal benefit rate, that's the presumed market value for whatever housing you're getting, even if the landlord would normally be getting $10,000 for that, but you're paying $400 or $334 it was last year, then they're not going to dock you the 1/3. That was a big move, and I think it benefits SSI people. They're not getting docked 1/3 if they're at least paying that 1/3. It used to be they'd be getting docked if they were paying something less. Now it's not so anymore. But I'd have to really feel out all the other in-kind stuff and see where that could slide sideways, because a lot of time there's unforeseen consequences of what you're saying, and then there's all these, as a result, then there's a lot of scammy, untoward things that we didn't realize would be going on. And that's the only thing I would like to see more on. But with regard to the rest of it, increasing the allowed asset from 2,000 to 10,000, I would totally support that. And what was the other thing? Wasn't there something else? Yeah, I think you were saying the benefit rate itself should be increased. And I don't even disagree with you on that, because even though that does get raised by COLA every year, it doesn't really reflect the increase in prices. We know that. It doesn't do it when it affects Social Security benefits for retirees and disabled people. It doesn't accurately reflect the basket of goods we need, largely probably because of housing, probably also because of energy, which is why it's so very important we get off this, yes, let's be dependent on every other country for our energy. Meanwhile, we have more energy than they have here. Laws of recent years refuse to let it go forward. And that's energy increases the food prices and the housing prices. Those are the big things. I would, that COLA, it doesn't reflect that stuff very well, for sure. Okay, Vivi says, if SSA most likely won't read a personal statement, do they read third-party statements? It's not that they don't read them. How much are you, if you have to read 5 million pages a day, going to read Vivi's extra 5 typed single-space pages she decides to send you when you gave her a form to explain things on? Think about it. Think about the attention span you're going to get. Everything you said in that 5 pages, Vivi, I swear to goodness, you could do it in the function report if you know how. If you don't, maybe get someone to help you. But it's true. And about the third party statements, we've all heard this before. Function report is hugely important because it can sink your ship. It's not going to win your ship. It's not going to win your case, but because you have to answer it and it can sink your ship, you need to know what you're doing when you do the function report. Third party statements, we often say it's just like useless, but if they ask for it, you want to give it and then make sure also it's not going to sink the ship. I think sometimes they're sent out to see if they will sink the ship, because then you've got a way of, the person pretty much just said they're not disabled in their function report. Third party statement, the reason why I say that's even far less valuable, but again, don't let it sink your ship, is you'll see in ALJ opinions all the time. Yeah, the statement by the spouse, I've read that I've taken into consideration, but I've also taken into consideration the fact that it's coming from a family member who would be, in so many words, biased towards the loved one. They're not completely unconflicted in the whole thing. So kind of the obvious, right? But you want to put the bang for your buck in where they're going to be appreciating it most, and that's your function report. All right. I know I could tell you're dying to give me your diary, but I'm just saying that there's a reason why they ask for specific questions and specific information, because it addresses the things that are relevant under the law to whether you're disabled. Your feelings and the long drawn out way of describing things isn't necessarily going to do that. It's going to be redundant and or irrelevant, because everything about your symptoms can be said in the function report. Yes, they can. I promise. We do it every day. Sherry says, I can't remember the precise reason why it stopped at 18. It was probably because you didn't meet the 18 and above rules. But I didn't start working for my mom until after we got back from Tennessee, because I also had cancer at that time. Oh my goodness, girl. At the time, I know it's a lot, but thanks. Yeah. Are you represented, Sherry? I know you're young, so you might have had trouble. If you want to fill out our eval, it's on I think it's scrolling across the bottom where you go for it. Tell them somewhere in there, put that we spoke online. Let me see where your details fit in to see if there might be a opening, particularly if I can pull you out of one that would be closed and into another based on certain things that we see. So I invite you to do that. I personally invite you to do that. I feel for what you've been through, and I really feel for the young people who didn't get to have the life of 50 years that many of us got before we went downhill. They haven't had that blessing or that fortune. They've been blessed in other ways, I'm sure, but it's the same opportunities just didn't exist, and the same comfort in living and all that. And it is pouring out there now. I guess I can't do that yard work when I get off with you guys. I'm so upset. Cleaning up all that dog poop and stuff. LaRocho says, Stephanie, reference hearings office canceled my, oh yeah, and I'm still waiting my application to release 2012 on my credits. Remote DLI, and in 2020 for widows. Okay, that was a different cancellation. They were canceling it for some reason. You didn't know why, right? That's really frustrating. You'd think it'd be nice if they had like another lawyer that could, not a lawyer, another judge that could step in and take ones that they know. Like, let's say the judge has to go have surgery and he can't do it that day. I mean, understandable reasons, right? Is there somebody else that, like a pool of other judges where they take them in, maybe change the time, maybe it's a day off, something like in the same time frame. That would be nice. And I think we might have touched on this other LaRocho. You can also waive the 75-day notice for the new hearing. I think it might already be that if you've already been scheduled for a hearing, they don't have to give you the 75 days. But if not, you can try to waive it yourself anyway. LaRocho says, that wasn't me. No, thank God. No surgery. They canceled, no rescheduling yet. Vivi says, it's 3 o'clock, guys. I've been going 2 hours. Should the third-party statements of people who know my daily limitations be written, or do they fill out the form SSA provides? Does it matter? Well, the SSA is going to send a 3380, the third-party function report, to the person you put down when they ask you for a contact. And you put someone down, and that's who's going to get the 3380. They actually gave you an opportunity now with the online application to mention 2 contacts, which was a newer thing the last year or 2. So they will send the 3380, and your people will have to answer them then anyway. If they already sent it a statement and then they have to do the 3380 and they forget what they said in the other statement, they might answer inconsistently. Do you want to risk that? I would wait till they get the 3380. Now, if there's a third-party statement this would be different. Let's say you have an employer, a former supervisor or coworker who, and I don't know your situation, but saw the severe struggles you were having with growing impairments on the job. That is something that I think can be useful because it's kind of coming from an unbiased person, like a supervisor, just an employer or a coworker who probably isn't going to be willing to BS a federal agency, and they're just describing what they saw on the job. It could be, pain observations. Maybe you had to take a lot of breaks and go to the bathroom, you called out sick a lot, had to leave sometimes early because your back would seize up. I don't know what the situation is. Or let's say it's mental health stuff and you were multiple times a week running to the bathroom crying. The stress of even that basic job would get to you, whatever. But whatever they saw, that can be helpful. That is not always easy to get. People don't always maintain relationships with people they used to work with. But I find those to be really worthwhile when they exist. They don't usually exist, but when they do, very helpful. So I hope that helps a little bit. And remember, these are my opinions on best practices, guys. Other lawyers and non-attorney reps can differ. These are mine. They worked exceptionally well as we built this from zero to what it is today and with the rates we have. So, but definitely reasonable minds can differ. So just take it for what it's worth. And I will not be offended at anybody not, embracing something I said, for sure. Now, my clients, on the other hand, don't have a good reason if they don't do it. One of a kind is in the house. Hello, one of a kind. Type 1 diabetic with A1C at 7.8. Ouch. Which doctor will not touch my back? It's too high. Any chance for a claim? Certainly for a claim. It sounds like you have a bad back, aside from the type 1 diabetes, because a lot of people can work with type 1 diabetes. But I'm curious about the type 1 diabetes and the high A1C. Do you have all sorts of symptoms related to that? How are your limbs, fingers, toes? Do you have wounds? Do you have syncope or, do you get out of whack where it's dangerous to even be in a light job because you need to be sitting down because things can go a little fluffy in the head? Those are the things I would be asking about. And of course, any other impairments you might have. Chance for a claim? Yes. The question is it a chance for a good claim, right? Siren's in the house. Hi, Siren. Do denials take longer than approvals? Probably not. But there is always kind of a myth that they do, that if you wait a long time, it's more apt to be a denial. And I guess it's because they know it's probably going to be appealed and they want to make sure it's ironclad written, following all the rules. So that's just like speculation. That's not necessarily true. Do I lean that way? I probably, maybe a little bit. I don't know. But I've gotten denials really fast too. So, and if I'm talking about ALJ denials, by the way, not down below. Yeah, that's true. SI, not SSDI. Okay, I'm not sure what that was in response to. PC says, I understand where you're coming from. No worries. Again, just a proposal. Yeah, no, for sure. And I love talking about this stuff. I'm not sure we should do it too long here, but I'm a big debater and I do a lot of white paper work on different issues for certain entities. So it's always I just always think you have to look at all the different angles. It's just why debating is so good. You get to hear the other person's reasoning. And then if you say, yeah, but you're not thinking of this, or vice versa, I mean, it's how we all can sometimes switch our minds because we hear something that we didn't think of before and no one else has said it. And then it can really make everything more clear, because if you don't see all the parts, you can hardly have the clearest of, interpretation. Siren says, if you are approved for SSDI, will you automatically receive Medicaid? No, you will automatically receive Medicare after the waiting period if you're still on it. Because SSDI, the beauty of that, it comes with Medicare, which is, in most of our minds, way more favorable than Medicaid. Medicaid is going to be based on your income. Now, if you're approved for SSI, in most instances, that is enough proof to say you're disabled for the state that you're in, and it's enough proof to say you're poor enough in the state you're in. Some states automatically have it that if you get SSI, they're going to give you Medicaid. And I kind of appreciate that and if you don't get approved for SSI, you can still apply for Medicaid because you can still use their long route to try to prove. But I appreciate the ones that say SSI, all right, then automatically this person, because they save their own resources. Why should they reinvent the wheel discovering whether you're disabled when the SSA has already said you are, and the SSA is extremely arduous? I mean, if someone can win through the SSA, darn sure they should be able to win through the state. You follow? In terms of disability. And because the SSI money situation, income, assets is very carved in stone and clear coming from why not just embrace that too, right? And that way that state doesn't have to spend more of its own valuable resources, which resources are always limited, whether it's money, labor, which costs money, redoing that finding to see let's see if you meet ours. We tweaked it a little bit. Why don't you just embrace that and save yourself the aggravation and your taxpayers' money? you know, just an opinion thought there. Sarah D's in the house. Hi, Sarah. I don't know that we've met. Would you say it's possible to appeal a hearing decision when the judge didn't take into account your extra breaks and days off from your FMLA work accommodations file? The judge listed 3 light jobs, I guess. Light said jobs. You mean light jobs? Those other light or they're sedentary. I could do, but she didn't take into account my extra breaks and days. Actually, what happened is she didn't find it credible that you needed those breaks. That's generally why she didn't have to address them, because she didn't find it to be so. That said, I would appeal. If you know that you can't do full-time work of any kind, you believe that to be true in your heart, I'd appeal. Don't ever, I mean, you went to a judge, you have to appeal to the appeals council. Whether you decide to appeal to the appeals council or file a new claim will depend on your particular circumstances, whether you can file a new claim, whether you're willing to forego your, all this also depends on the strength of your legal case, which would be your vocational profile, along with all your medical records and how strongly they were. I mean, ad nauseum, they have to be very, very, very strong and robust and continuous. And I always say your full-time job, but it's not 40 hours a week. And that's how we expect our clients to be. It's got to be your main priority, you know, outside of getting your treatment. It's got to be right up there. So I hope that answers your question, Sarah. If you can appeal, you can consider doing that. If you can't file a new, you have no choice but to appeal to the appeals council, or else the thing dies forever. That's some of the big major rules of thumb I could tell you without knowing the details of your case. Hey, Jen Mee's in the house. Hi, Stephanie. Hi, Jen. Just got here. It's interesting then what they read and don't read. It's clear that someone read every word of my therapist session notes. Well, that's medical evidence. So, and I think they technically have to review everything. Now, sometimes things are illegible and they can't be held to know what's in an illegible document, right? But, you know, the rule is they have to consider all evidence submitted. But then the question is, well, do they have to give it certain weight? No, they do not. So that's where I think the confusion sometimes comes in. Yeah, I read that and I gave it very little weight because, you know, and if they don't explain why for certain things that are very robust in the record, and they don't explain how they came to giving it no weight, or they don't explain what weight they gave it at all, that is an appealable issue oftentimes, because that's part of their job when they make the decision. Medication side effects, Sarah's talking about. Yep, very important. We have some videos on that. Very important. Jen Mee says, also, my lawyer the other day looked at my therapist's functional report from the past before I met these lawyers and said kind of to herself, all severe, that's not good. I said, why? She said, hold on. Oh my God, I'm sorry. My clicker's not working. She said, because then it looks like they're making it up. And I'm just like, or maybe like the situation is really bad. Yes, but your lawyer has a very, very good point. I mean, it depends on which aspects, of course. So I can't speak to your case specifically, but let's say it says, how can the person communicate? Severely impaired. Well, like for instance here, Jemmy, you are an excellent communicator. You're an excellent writer. You're very astute. You have a strong thought process. You know what I mean? So it really depends on what they said is severe. Like, let's say you could be agoraphobic. You could still be a fabulous writer and strong thinker, but if you can't leave the house, guess what? You can't go out and do any of those jobs that exist in substantial numbers in the national and regional economy, right? It's huge. It's hard to prove, but it's been done, and that's through that really. So really, everything is so specific, but your lawyer is not incorrect when she says that that's the way it can optically come out. Like, wow, that person's probably in a straitjacket right now, living in a closet, or because if everything is severe, that person couldn't even pick up the phone or maybe even send an email if their communication skills were severely impaired. No, because it's not going to ask on a mental or her talking skills impaired. It's not going to be that. Or her in-person, it's not going to say that. So, I mean, I know what's on those forms, but you are correct in that in very rare cases, like your own, everything is severe. Now, everything on that list, you got to, that's why I'm glad you have a lawyer, because they're kind of stepped away from it where you can't be, because you're living it every day of your life. And they can help try to, couch things in a way that is a little more maybe realistic optically